middle of something?
Agreed to redactions on it yet.
Oh, I thought that was 170C. This is what I gave you.
I know,
To look at.
but these are what my proposed redactions are, which are somewhat similar to yours, but
Yeah.
I object
I really
to
like
the
peppers, they're
references
so
to those
sweet
things.
though. Like, that's like
But
a
if
dessert
you-
candy. Peanut butter cup is like a
That's
fruit.
actually, I think, the only difference.
That's your main.
But this was part of our case.
Probably.
No, I'm just saying,
Possibly.
I'm just.
Like, who
confirming. I
knows,
don't-
right?
I think all these remaining redactions, apart from this.
Oh, it's like a consumer. Do you guys
Yeah,
want to
'cause-
talk about the verdict form?
Sure.
I mean,
Yeah,
is there something you want changed?
I largely agree with it. There were just two things I thought we discussed. One, I thought there was gonna be some reference in it to clarify that the comparative fault doesn't apply to the first two. I mean, maybe it doesn't matter and the way it's structured is fine. It just, I wasn't sure if the jury might be confused by that, but.
So I don't think it needs to be changed, but I understand your concern, and so, so I talked to them about it in the instructions, however, it's not actually written in the instructions. So is there a place, do you want me to just put, so for like question 2 and question 4, do you want me to just put in parentheses, the affirmative defense of comparative fault does not apply to this claim? Something like that?
Yeah, maybe
Okay.
see what they think about that.
I'm not opposed to it. I think it's clear as is because comparative fault doesn't come up. My only concern is that
Doesn't come up until the end.
doesn't come up until the
It's in the
end.
negligence section.
So I think it's clear as is, and obviously from our perspective, we don't want to overemphasize
Right.
the non-application of it.
I think my concern is that the damages portion only comes, there are no, if there were damages sections under each individual claim, then it wouldn't bother me, but we go through all those claims and then you only get to writing out the damages after they've been given the comparative fault instruction, so I'm not
Okay.
sure what the most appropriate place to add it would be, but it just seems to me that as written, they could confusingly apply it to the damages section that's at the bottom.
Okay, so I understand the city's concerns, but given that I'm not even sure this is actually a valid defense to the negligence claim, I am just gonna put the defense of comparative fault does not apply to this claim in parentheses for question 4.
Can we say plaintiff's comparative fault? That may seem nitpicky, but I don't want there to be any confusion with like justification or reasonable force.
Well, but then that kind of presumes that there was any fault by the plaintiff to articulate it that way.
Okay, so it is a defense, so calling it a defense is accurate. So I'm just gonna say the defense of comparative fault does not apply to the assault claim and then to the battery claim.
And then my only other issue was, it sort of says, so the first line of relating to unreasonable force, I don't have any problem with generally the way it's articulated, but it says it at the end, like, use of force with a baton, and I think it would just be cleaner and less likely to lead to confusion if it just said use of force against plaintiff and just left it at that.
Now, this case is done about a baton push in the back
So
and a baton strike.
what you say makes sense. The problem is there are 4 force incidents, and only 2 of them, the latter 2, are the subject of the tort claims. And so
Right.
I think they could conclude that the first 2 were unreasonable, and it's just important to focus them on the second 2 incidents with the baton.
No, and I accept that. I guess what I'm saying is, like, they might be like, I don't know, they might confuse that for only the part where she gets hit with a baton, where you're sort of using a baton as a baton instead of a thing to push somebody with, but it's, anyway, it's maybe nitpicky. I just thought it would be easier to not have that sentence in there.
So I'm gonna leave it the way it is, but you should talk to the jury in your rebuttal about the verdict form
Okay.
and how they need to think about it. Okay, and so does the city wanna talk about the verdict form?
No, Your Honor, I do recognize that plaintiff has the opportunity in his rebuttal to reference the verdict form. So I'd like to make that decision after his rebuttal, but I don't expect that, just if there's something to clarify in his characterization or explanation of the verdict form. But as the verdict form stands now, in a vacuum, without any argument, I have nothing to say to the jury.
So if I understood you, you're saying you don't wanna talk to them about the verdict form now, but you might wanna talk to them after Mr. Burgess talks to them?
I don't think so, but perhaps he does have the benefit of addressing the verdict form to the jury, and I did not have that.
Right, and what I said before we broke for lunch was you can talk, your closing can continue after lunch if you want to talk to them about the verdict form, and I think if,
Oh, so before Mr. Burgess
Yeah,
goes.
I
Oh,
think
I
just
misunderstood.
the way it works, it wouldn't.
I do not want to just do like a 2-minute or
Oh,
with the
okay,
jury.
but you have that option.
Okay, thank you.
Yeah.
I'll decline.
Okay, and so then what do you want me to tell them about this section in the verdict form with damages? This is where, like, I think it just makes more sense to let them award damages on each claim if they get there, and then just do the math after the fact. With the instruction that I've given them on no duplicative damages, if I were sitting, I think what it means is if you award all of the economic damages on the assault claim, you can't award it on the battery or negligence claim. Is that how everybody else understands that instruction?
I'm sorry, can you say that one more time? I didn't.
So the last instruction I read to them is called no duplicative damages. And what that instruction says, as I understand it, is you can only award the money for the thing once. Meaning, if you award all of the economic damages requested for the assault, you can't award the same economic damages for the battery or the negligence. Which I think is more confusing than if you just have them reach a verdict on each claim and then
Like, we just get whatever the highest one is once.
it's just yes, or it's just, I'm guessing it's going to be the same number each time.
Well, I speak.
Yes.
The same number, I mean, first of all, it should be clear from your verdict form and the instructions that they can't put 15,606 for assault, 15,606 for battery, 15,606 for negligence. That should be clear, and hopefully that won't happen. With respect to, I mean, if there's a 0 on the assault and a 0 on battery, like we've talked about, then the negligence claim is irrelevant. It doesn't matter. If she wasn't assaulted, she wasn't battered, irrespective of what the city's negligent training was on the use of the baton, they don't get to recover that.
Right, and the instructions direct the jurors through the verdict that way.
Oh,
That's what I understood it to be saying.
But the way that this table is set up, it's inviting them to reach a verdict on each of the claims. Reach a damages award on each of the claims.
Your Honor, Mr. Manlove and I should discuss, but if there's a stipulation that if they put damages throughout, and then we go with the highest number, but I guess my belief was that if they did damages throughout, they might get confused and say, and duplicate damages inadvertently.
Okay, so this is the city's table. So how are you envisioning this would be filled out?
Well, maybe they put 0 for everything. I mean, I would call that a good
Ideally.
day.
And that's not confusing. It gets confusing if they start awarding money.
Right.
Yeah.
I guess I envision they might say, okay, apprehension cost $3,000. The physical contact caused 10. The training caused another 2. I was anticipating there would be different numbers for each one. But if they were to go through and do it through each claim, and I mean, tell me if I'm wrong, but if they did that as they went through the claims, then 2 for assault, 5 for battery, 3 for negligence, like, would we just go with the highest number? Is that what the court's saying?
I think that that's how it would work, but the problem is like,
We could have assault and battery be like just one box, I suppose.
the problem is that like the negligence, if they start awarding numbers for the negligence and it's discounted by fault, it doesn't matter. And if they've awarded money, I mean, they could find for the plaintiff on assault, but not, maybe battery, but not assault, or assault, but not battery.
Correct.
So it doesn't seem right to tell them they only get one verdict for those claims, or they only,
Your Honor.
does anybody have a solution?
Well,
That's what I'm looking for.
So plaintiff's verdict form had under assault, it had, because under assault, she wouldn't, I even had it separated out in terms of the variety of economic damages that could be awarded, because under assault, presumably, she wouldn't be entitled to the arm injury damages from the assault, because it's an attempted battery. So it would just be or the lost wages, because that resulted from physical injury, so that she would be, limited to non-economic damages and then the psych medical records, presumably. And then
Assault? For which one?
for the assault claim, because she suffered from emotional distress and PTSD that arose out of that incident. Right, so she could recover the psych, which is
Okay.
like $3,000. I'm not trying to make a big deal out of it, but
No,
my
no.
only point is, similarly, and then which is, my point is, we enumerate, each claim had a separate section for damages based on the damages that could be awarded, and if you did it sequentially that way you can say, as you go through, it takes care of the problem of the duplicative damages, in my opinion, because then, for example, if they go through those first 2, then they skip, and if it's a defense verdict on claims 1 and 2, then they don't go to the negligence claim, they don't start writing numbers in. I just think this graph table at the end is confusing, and it doesn't serve the function of avoiding the jury writing multiple different.
The city is not married to the table, so, I mean, whatever the
I
court
guess,
thinks.
so here's what I'm looking for. I'm looking for a solution that lets them award the damages at the end so that the instructions don't need to be rewritten, because that's the hardest part of the verdict form, is making sure the instructions all make sense. And I don't necessarily have the solution.
I think you could just have at the very end, you could still do it sequentially, and instead of in a graph, it just says damages, and it just says, if you found, for plaintiff with respect to assault, and then it just puts the damages, and then it says if you found for the plaintiff for battery, then it has the damages available there, and then it says, if you did not find on either of those claims, then do not proceed to the next section for negligence, and then, but if you did, then if there's a negligence claim, negligence damages, then award those, and then it wouldn't, I think that would
Do you
avoid that.
have a thought?
One thought is, for question 11, what are plaintiff's damages? Question mark. And then, yeah, Caroline, if I get this wrong, but then, economic damages, also a line, with the parentheses, cannot exceed 15,000, and the non-economics cannot exceed. I mean, I'm not sure if that because I think the way the verdict is structured, you know, like I said a few minutes ago, if it's no on assault, no on battery, then I think it's directed them to sign the form and it's all
Yes.
done. So it seems like that, what I just described, getting rid of the chart and just having those questions, you know, without focus on each claim, avoids that issue of having them invite, you know, some kind of award for each claim.
Is that what?
But is it
You may have.
No, I can't tell if what I'm proposing and what you're proposing are different.
Is it important to know which, so assuming there's some money awarded on all of the claims, is it important to know which money is awarded on the battery versus the assault? I feel like the negligence question is like kind of an advisory opinion, because you don't get there unless there's a finding on the assault and battery.
But it has to be separated out if there's any comparative.
Right, but they do that in the questions.
Right.
Then it might make sense to have that, so the top half of that graph at the end of the intent of the assault and battery claims, and then it just says, what are your damages, you know, assuming you found for the plaintiff, you put, you know, you have a graph like this that sets forth assault battery with the same graph they have, and then do the negligence section with the comparative fault, and then have the bottom part where it says, so that it just separates them out in terms, so that they're not all on the same graph together, because I think that.
So are you okay with combining assault and battery?
Well, I think the one feature of it is, like, obviously, we wouldn't be able to obtain. Yeah, I don't care, that's fine.
Is the city okay with combining assault and battery?
I think so, if plaintiff is good with that.
Then there's still a complication if we're asking them for the negligence numbers after the instruction telling them not to award the same money twice. I need to tell them really what to do there. Because if they do it again, we can just ignore it. But if they're following the instructions and they've awarded money, I guess it's possible that they could award. It seems to me like the damages are the same. Like
Yeah,
the damages are kind of capped at the total of whatever the damages are for assault and battery, unless you think there's some additional harm caused by the negligent training. But I think the damages are all of the claimed non-economic damages are for the battery and the assault act.
Yeah.
I completely agree. I mean, if plaintiff wants to waive economics on the negligence claim, I mean, that would make sense, just like draw an X through that box. But like, I don't feel like that was something I should propose.
Right.
Like,
Well, it's just
like
like.
that'd be the way to deal with that, is
'Cause
just.
It just seems like the negligence claim is like you know, a spandrel, and, you know, it's like, either if plaintiff wins on the battery claim, then it's unnecessary, because you already got the damages from the battery claim, and if you lose on the battery claim, then there's no negligence claim, so like what purpose is it
We can
exactly
just take-
serving it?
We can
We-
take the
we
negligence claim off.
No, but I guess I hadn't thought of the possibility that she raised, which is that there's like, you know, on the non-economic damages, they award like 10 grand for assault, 50 grand for battery, and then like the remaining prayer on negligence would be, I don't know what to do with that kind of an award. Like, because at that point, you're not, clearly the jury is sort of feeling that they were, I don't know what to make of
Okay,
such an award, but I
so-
don't think it's improper.
I don't know if this is going to be helpful, but I would like to do is take like a 5-minute break and see if you can reach some kind of an agreement about how to deal with the damages award section.
Okay.
'Cause it's going to be better for everyone.
Was it sent in Word, by the way? I'm sorry.
I think so.
I'm really trying to connect to the internet, I promise. Can I just use my phone? I don't know what is going on here, but I think that maybe a way to.
John, I had troubles too, if you have to like kind of dismiss that.
I know, but it won't.
Well, like they said, looks like we're going to be taking a break for about 5 minutes while they try to negotiate how to handle this snafu. Basically, the problem they're running into is there's 3 different counts that, depending on how things shake out, a jury could find monetary, non-economic amounts for. But they have to make sure that it's completely clear that each amount has its own distinctive charge and that none of it is combined. Like, you can't say that, well, we're charging $10,000 for the assault, or like they can't say we're charging $10,000 for the assault and also $10,000 for the battery as though it was the same pot of money. It's the assault is $10,000 and the battery is an additional $10,000 separate. So they're trying to make sure that the jury instructions are completely clear on that to help, avoid confusion from the jurors, as well as if for some reason there was an appeal of this, this helps to make sure there's no legal questions that could trigger an appeal. That said, I'm going to go ahead and put the music on for a couple minutes. So kind of shaking off this lethargy from the meds I had to take this morning. So we'll be back in a couple minutes here.
So I put together one that sort of puts it's not in final, but I basically just, to give an idea for everyone. I emailed it out. It just says, after each claim, it just says, what are plaintiff's damages for this claim? And then underneath that is economic damages and non-economic damages. And I tried to adjust the numbers
Okay,
in those because obviously, because we had to add a paragraph to each claim.
okay.
So, it would change. I think it's not in final in terms of like the paragraph that goes after
Okay.
6. Or, but I just think that's generally how verdict forms look, is where the damages for each claim come after the claim itself. And plaintiff's position is that assault and battery are not identical claims, and
They're not.
they don't have identical damages, so the only time when it really comes up where you'd be like, oh, are these duplicative, is if they put like 450 under each one of them, and then it wouldn't matter because it would exceed the total amount anyway. Whereas if it's like, oh, they give me 5,000 for the assault emotional distress, and then 200 for the battery emotional distress, then they're obviously not overlapping. So then
This doesn't solve any of the problems that the table does, though. It just distributes the problem throughout the verdict form rather than containing it at the end. It doesn't fix anything.
okay.
Yeah, I,
My suggestion, what are past damages?
yeah, Mr. Manlove suggested we could combine assault and battery, into one. I wonder if also after the battery portion, asking for damages, if in parentheses we could put something like, your damages for this claim should not be duplicative of any damages awarded for claims above. To emphasize that the damages need to be unique for each claim.
Okay, say that again.
So, the jury's gonna get to the assault damages, and I think from our perspective, the concern is they'll put 450 or 15 or whatever, and then, or 6, and then they'll put 6 under battery, and so when they get to battery damages, there could be something in parentheses that says your damages for this claim, should be unique or should not be duplicative of damages awarded above for the assault. And if that's put then again under the negligence, the idea being that the damages for negligence should be unique from the damages for battery, from the damages for assault.
So I'm starting to think that there is really no harm in just asking for the damages once. Because, battery and assault are different claims, but they're essentially claims, they're like alternate, or they're sort of like slightly different theories for the same physical conduct. So the harm is the same, essentially, because it's the same conduct. It's the hitting with the baton and the falling, the injury caused by the falling caused by the hitting of the baton. And then whatever is awarded, if anything is awarded for the negligent training, that is clearly duplicative of whatever's been awarded for the harm from the touching.
But if the jury awards any comparative, then it has to be parsed out for the court to make a reduction.
Yes, but it kind of doesn't matter, because even if the damages on the negligence are reduced, if they're not for the assault and the battery, maybe the thing to do is to just leave the table as it is and just, they've got the instruction that they can't award the same money twice. And then they decide where to put it.
That's fine. That's fine with me.
The trouble with that is, well,
I think it makes sense to split it into two and have the assault and battery above the negligence claim, the same chart, but above. Because I think, like I said before, I have concerns that they will attempt to make some kind of percentage alteration or, by looking, after looking. at the
okay, and you can talk to them about that,
Okay.
right? They've had an
Okay.
instruction about that, and then that's why you talk to them. So I think the form,
Then just keep the form. as
okay,
is.
so the form
Oh, yeah.
with just the assault and the battery parentheses telling them, it's fine. Yeah,
I mean, I made this suggestion earlier before the break, before lunch. Again, using the form that the court provided earlier with respect to question 11. What are plaintiff's damages? Question mark. And then we just have assault and battery, and then below it, a line for economic, non-economic, and then negligence, economic, non-economic. With the provision that total damages shall not exceed whatever.
okay, and that's something that Mr. Burgess, it sounded like at one point he agreed to combining the assault and battery.
Well, I mean, I see the person running at her is the assault, the actual physical contact is the battery. So, I mean, conceptually, they're not identical in terms of the damages available.
Okay, then I'm just gonna leave it as it is. It's not wrong as long as they follow the no duplicative damages instruction, but I guarantee there's gonna be a question probably from them, but.
Can I just confirm, this is, the defense of comparative fault doesn't apply to this claim?
To this claim, yeah, okay, I got it. Right.
Are the exhibits ready to go?
We have one issue
Okay,
relating to one exhibit that didn't get resolved yesterday.
can we take it up after the jury goes out?
Sure.
Okay.
We can.
Yeah, unless you were intending to send them with
That's a kind of a multi-step process usually.
Fair enough, then we can take it later.
Like a trickle.
Can I have a printed out copy of the verdict before
Sure
I?
can. This is your copy, but also the jury copy.
Okay. And this is a little odd, but I think maybe I'll read them the verdict form before your rebuttal.
Okay, yeah, no, that's fine.
And this is the.
Thank you. Yes.
All right. Yeah,
That's all good. I can't hear that one. Okay, here's the final.
Oh, cool. Thanks, they're obviously 171.
That's the only thing.
And he would say, you have AP. But it's giving an option, absolutely. please be seated. Before we hear the rebuttal on behalf of Mrs. Wenzel, I want to talk to you about the verdict form. The verdict form, and again, like the jury instructions, it may be helpful to have multiple copies of the verdict form so that everybody can kind of walk through it. Only the presiding juror will fill out the answers once there is a verdict, but it may be helpful for each of you to have it as you go along. And so it's a, how many page document? It's a 3.5 page document, and it's divided into 5 sections. And there are questions in each section, but you may not need to answer each question depending on your answers to some of the previous questions. And the instructions for how to go through the form are in italics. And so it says Erin Wenzel versus City of Portland, and there's the reminder at the beginning, at least the same 9 jurors must agree to the answers on the following questions. We, the jury, find. And then the first section is a question about unreasonable force. And the question is, did one or more Portland police officers use unreasonable force against Erin Wenzel with the baton on August 14th, 2020? And then there's a place for the verdict of the jury to either be yes or no. And then the instruction is, if you answered no to question 1, then your verdict is for defendant. Do not answer any more questions. The presiding juror should sign and date the form. If your answer to question 1 is yes, go to question 2. And then question 2 is in the second section titled assault. So that's one of the 3 claims that the plaintiff is making against the defendant. Question 2 is, did one or more Portland Police Bureau officers assault Erin Wenzel on August 14th, 2020? And then there's just a reminder in parentheses there, the defense of comparative fault does not apply to this claim. And there's a place for the verdict of the jury to either be no or yes in the answer section. And then the instruction is, if your answer to question 2 is no, then proceed to question 4. Do not award any damages for this claim in question 11. If your answer is yes to question 2, then proceed to question 3. Question 3 is, was Erin Wenzel harmed by an assault by a Portland police officer on August 14th, 2020? And then there's a yes or no answer space. And then the instruction is, if your answer is no to question 3, do not award any damages for this claim in question 11. Regardless of your answer to question 3, proceed to question 4. Question 4 is in the section entitled battery, and battery is one of the 3 claims that the plaintiff makes in this case. And the question 4 is, did one or more Portland Police Bureau officers commit a battery against Erin Wenzel on August 14th, 2020? And then there's a reminder in parentheses to you that the defense of comparative fault does not apply to this claim, to the claim of battery. Then there's a yes or no answer space, and then an instruction. If you answered no to question 4, then proceed to question 6. Do not award any damages for this claim in question 11. If you answered yes to question 4, then proceed to question 5. Question 5 states, was Erin Wenzel harmed by one or more Portland police officers' battery against her on August 14th of 2020? Then there's a yes or no answer space. And then an instruction, if you answered yes to question 5, proceed to question 6. If you answered no to question 5, then only proceed to question 6 if you answered yes to question 3. If you answered no to question 5, do not award any damages for this claim in question 11. If you answered no to both questions 3 and 5, your verdict is for the defendant. Do not answer any more questions. Sign and date the verdict form. And then the 4th section is negligence, and the first question there is, was the city of Portland negligent in its police officer training in one or more of the ways plaintiff's claims? And then there's a yes or no answer space. And then an instruction, if you answered no to question 6, proceed to question 11. Do not enter any damages for this claim in question 11. If you answered yes to question 6, then proceed to question 7. Question 7 is, was the city of Portland's negligence a cause of harm to plaintiff? And then there's a yes or no answer space and an instruction. If you answered no to question 7, then proceed to question 11. Do not enter any damages for this claim in question 11. If you answered yes to question 7, then proceed to question 8. Question 8 is, was plaintiff negligent in one or more of the ways the defendant claims? And then there's a yes or no answer space and an instruction. If you answered no to question 8, then proceed to question 11. If you answered yes to question 8, then proceed to question 9. Question 9 is, was plaintiff's negligence a cause of harm to herself? Then there's a yes or no answer space and an instruction. If you answered no to question 9, then proceed to question 11. If you answered yes to question 9, then proceed to question 10. Question 10 is, what is the percentage of each party's actions that caused damages to the plaintiff? And then there's a place to write the relative percentages of the percentage of the party's responsibility, defendant and plaintiff. The percentages must total 100%. And then it says, if the plaintiff's percentage of fault is greater than 50%, do not enter any damages for this claim under question 11. Proceed to question 11. And question 11 is in the section entitled damages. What are the plaintiff's damages for each claim? And then there's a table, and the claims of assault, battery, and negligence are listed out. And then there's a column for economic damages, and there's a reminder that they can't exceed, all of these can't exceed the total of $15,606. And then for non-economic damages, a reminder that the total damages can't exceed $450,000, and then a place for the presiding juror to sign and date the form. Right, and now we are ready for the rebuttal.
Good afternoon. So I'd like to, at the risk of boring you, go over the verdict form that we were just discussing. And so I think that it would be helpful to go through it sort of piece by piece from the perspective of how this applies to Ms. Wenzel's claims. So under the first question, which is, did Portland police officers use unreasonable force against Erin Wenzel? I think the answer here should be yes, because the Portland Police Bureau has not brought a witness forward to explain why their use of force would be reasonable. And their own witness, Lieutenant Shaning, when he was asked on the stand on Friday whether or not the use of force described by Ms. Wenzel was reasonable or whether it was appropriate under the city of Portland's own policies, the answer was no. So if it's not appropriate under their own policies, then it cannot be reasonable under this, and you'd have to answer yes. One of the officers did use unreasonable force. The next question is, did one or more of the officers assault Erin Wenzel on August 14, 2020? And so the assault is kind of a tricky concept, because it's, although in everyday speech when we say somebody gets assaulted, we mean someone was physically assaulted. Whereas the claim, this claim, as the jury instructions, which you can take a look at, make clear, is really an assault is an attempted battery or a battery that's about to happen. So, and then the battery is the actual hitting, the actual physical contact, okay? And so the threatened or about to happen battery is the assault. And so since the testimony is that as Ms. Wenzel looked over her shoulder, she saw an officer bearing down upon her, the answer for under question number 2 should be yes. Whether she was harmed by that assault, again, the answer should be yes. Her testimony was that this caused her emotional distress. Now we come to the battery section, and this is, I think this is where this is the most important part to look at. Because here it says, did one or more Portland Police Bureau officers commit a battery against Erin Wenzel on that date? The defendants have not put forward any evidence to dispute
that this is what happened? And Ms. Wenzel credibly testified that it did. So the answer would be yes, and that she was clearly harmed by it. She went to the hospital. She had a broken elbow. She underwent treatment, physical therapy. There's no dispute about any of this. So she was clearly harmed. So the answer to number 5 should also be yes. And it will get a little bit tricky because then you'll get to the end. And I just want to go over that part of it with you for just a moment, which is that you've been instructed not to give duplicative damages. So if you gave damages under the non-economic damages portion for the assault, then you'd have to be giving different or additional damages under the battery. So that if you were awarding damages in this case to a total of $450,000, which plaintiff has requested, then you can certainly put all of the damages in one section if you wish, but if you want to apportion them out between the assault and the battery, then they would need to be different damages. I think an important thing to go over in the negligence portion is that even though it's clear that the City of Portland's official policy would not permit the kind of use of force that Ms. Wenzel experienced, what was clear is that the people who were in charge of training these officers permitted this to occur, and that this was a practice that was going on the night in question. And so in answer to question 6, was the City of Portland negligent in its police officer training in one or more of the ways? The plaintiff claims the answer should be yes. And was their negligence a cause of harm to the plaintiff? The answer is also yes, because that culture of permitting this type of use of force is what allowed the officer who did use force in the way that it happened was the cause of harm to Ms. Wenzel. Now, the next questions are going to be confusing because it says, was plaintiff negligent in one or more of the ways the defendant claims? And the problem is that it's not at all clear what the defendant is claiming Ms. Wenzel did that was negligent. Apart from being at the protest itself, there's no claim that she was doing something that invited this attack on her from behind. And so your answer to question 8 should be no. And the same is that she did not cause the harm to herself. She did not run into herself with a baton. Somebody else did. So your answer to question 9 should be no. And since you answered no to 9, then you would skip 10 and go straight to the damages portion. I don't want to keep you here for too long. I think that a number of the things that you heard in the city's closing are either inaccurate or are not reflected in what was contained in the evidence. I think there's a lot of implication about what might have happened, but nobody's saying what actually happened. I think you would be forgiven from walking away from that closing and not knowing the answer, which is really the only answer. Well, not knowing the answer to the only question that's worth asking, which is, are they saying it didn't happen or not? And I can't tell if they're saying it happened or not. First, they say, we're not saying it didn't happen, but then they're inviting you to speculate that it might have happened because of another protester, as though Ms. Wenzel couldn't tell the difference between a person clad head to foot in riot gear and another protester. They want to just sort of paint things in an air of ambiguity and chaos and say, who knows what happened? But the reality is, Ms. Wenzel knows what happened, and she told you what happened, and her testimony was not inconsistent. The fact that she felt like her elbow hurt and that something might have happened to it and that a paid expert disagreed does not mean that she's lying. She hurt her elbow. It turns out not to have been broken, and that isn't some kind of misrepresentation by her. Plaintiff asks that you award the damages that we've requested. which are $15,606, and economic damages, which are reasonable and actually quite low, given the amount of work that she lost and the amount of medical procedures that she underwent and the treatment and care she received. We're requesting $450,000 in non-economic damages, as we have already indicated, and we request, as I mentioned before, that you hold the city accountable for their actions. Thank you.
Thank you, Mr. Burgess. All right, I have two short, I'll call them housekeeping matters. Maybe this is more important than housekeeping. So Anna, I need you to take the special oath for jury deliberation. So will you raise your right hand? Do you solemnly swear or affirm that you will take charge of this jury and keep them together until they have reached their verdict, and that you will not, unless by order of the court, allow any communication to be made to the jury except to ask them if they have agreed upon a verdict, and that you will not communicate to anyone the state of their deliberations or the verdict they've agreed upon, and that you will not perform these, and that you will perform these duties to the utmost of your ability?
Yes.
All right, thank you. And I also have to tell you that the alternate is juror 2. So what that means is you will not deliberate unless there's an issue during deliberation. If we call you, please answer. But at this point, you will not be deliberating with the jury. I don't know how you feel about that. Sometimes alternates are happy, sometimes they're really frustrated. And so I just want to say thank you for your service. And we will absolutely email you the verdict. Thank you. The other thing I want to mention, jurors, is that it may become necessary for you to communicate with me during the course of your deliberations. Sometimes juries have questions, sometimes they don't. I can't answer any questions about the evidence or what it means, but jurors have questions. And so if you have a question and you want to talk to me, you need to put it in writing. Please don't use any abbreviations. When I get the question, I have to talk to the lawyers about what my answer will be. And so depending on where they are physically, it might take a little bit of time for me to get you an answer back. My answer will be in writing. So that's one thing I'm telling you. If you need anything else, please just let Anna know. And at this point, we are giving this case to you. It is in your hands to decide now. Thank you.
I will take your notebook. And you probably. Sorry.
Oh, sorry.
So, okay, so there's some exhibit that you're still talking about
Yes, Your Honor.
or
So we've,
disagreeing about? Which one
We
is it?
disagree about only one very small portion of the
Okay,
document.
is it the email
Yes.
from Dobson?
Yes,
Okay,
I've redacted everything in accordance with the court's ruling, which is acceptable to Mr. Burgess. And then, however, there's a sentence in here that says, the first paragraph, the end of the first paragraph says, quote, "We made several custodies during this time and took several projectiles, rocks, lasers, paint," redacted, "mortar shell, glass bottles," close quote. And he's objecting, I guess, to the inclusion of those items. However, Dobson testified about projectiles. He testified about rocks, lasers, mortar shells, and I think he testified about glass bottles, although I'm not sure. He did testify about a soda can.
So what I heard of the testimony was that it included lasers, paint bombs, a firework, and water bottles. But there was no testimony during the days of trial about one. First of all, there was an exhibit they had offered, but then was, as I understood it, was removed on motions in limine that was a picture of a rock. He did not testify about a rock, and even if he had, it being in this email none of the witnesses who were who we've heard testimony from said there were rocks thrown. And I think it's highly problematic to backdoor that allegation in to get to the jury information that they couldn't get in through people who were actually present that day. Mr. Dobson was not there. He was miles away by the airport. He could not possibly have known whether any of this information is true, and it's highly prejudicial to the plaintiff to have all of a sudden these allegations of glass bottles, and then to refer to a firework as a mortar shell is also, you know, highly tendentious, if not inaccurate. And to put that in there is prejudicial to the plaintiff. If they wanted this kind of information and it needed to come in through the front door and an actual witness, and they knew they couldn't get it in that way, so now they're trying to get it in through an email that is basically hearsay.
Dobson was testifying about the activity log. He was reading through it. He also testified that he was aware of this information. Even though he was out at the airport, he testified that he was getting information from police officers on the ground, from the airplane, from live stream video, from open source content that was posted in the command post. So the fact that he's allowed to take that knowledge, and this is a summary of the night's events, and it includes these projectiles.
So is there a glass bottle, a rock, and a mortar, mortar round or mortar?
I think it's a reference to like fireworks that shoot up in the air.
Is that in the activity log that's already in evidence?
I believe so, yes. It's a commercial grade firework.
Is it just called a firework in the?
It's called-
That was
it's
what the
called-
witnesses called it,
it's
was a
called-
firework.
In the activity log, it's referred to as a mortar.
I think there is a reference to, it doesn't say shell, it says we took a mortar at one point.
Is
in the
there,
activity log.
are there rocks and glass bottles in the activity log?
Rocks are included. I'm not sure about the glass bottles.
Okay, I guess.
So
can
I
you
don't see that. You'll have to point
redact
out.
glass bottles, and can you redact the mortar thing? Just, I mean, the glass bottles, that, I remember testimony about a plastic water bottle with
Yeah.
this water in it.
The mortar thing, you mean the mortar, to take out the word shell? Because mortars are referenced in the activity log. We took a mortar.
Okay, I guess just cross that out. This is not how you win or lose your case.
No, I understand. I got really fired up about this 3 days ago, so now it's
All
maybe a
right,
little.
so you're just honoring your past self?
Yeah, I'm just,
Okay.
that
That
I'm
makes
just,
sense.
I'm
So,
just.
so it's take out the word
Shell
shell.
And maybe even just glass on the
Shell
bottles.
glass, okay, shell glass.
All right,
And then, just so that we're clear, like I said earlier, Your Honor, just for the record, I had offered, the city would offer 170D, which contains these redactions. However, it does have information with respect to where the crowd was going, to the Portland Police Association building or to the North Precinct. And that's, I understand from Ms. Ellemeyer that, we keep that, but that's just for the purposes of preserving the record. Like I said earlier, I believe that Commander Dobson should have been able to testify that in some cursory fashion.
But in the document itself, it's redacted.
In this exhibit that's gonna go to the jury, it is redacted.
Okay.
And I also, can I just put on the record very briefly my objection to the good faith jury instruction?
Yes.
Okay.
Yes.
Okay, so I think I already I'm not going to repeat the reason why I gave it earlier. I think that it's, beyond the scope of what was authorized by Rich B. Cooper, but, and so plaintiff objects to that the inclusion of that jury instruction. Thank you, Your Honor.
Thank you.
Do you want me to put down our cell phone numbers on the
Yes,
piece of paper?
yeah, and so where are you planning? I don't think this verdict is gonna be a fast, I don't think it's necessarily gonna be a slow verdict, but I don't think it's gonna be a super fast verdict.
I
So
was
where
going
are
to be
you
nearby,
planning?
but like within a few block radius. Of
Okay, I just need you, my only concern is if there's a question, but we could also talk by phone. Okay.
Can I have a?
So,
I'm giving myself first.
you figure
Oh,
out.
okay. I was gonna put them all on one sheet,
Yeah.
but,
Yeah, so I admitted
fair enough.
an amended version of 170.
do you have I'll just put it.
Okay, well, there we have it. Deliberations have begun. It is now the waiting game. I'm going to go ahead and reach out to the court clerk to try to see how they prefer to handle letting media people know when a verdict is going to be ready to be read. And once I have an idea of what's going on, we will be able to go ahead and get a stream going for that. In the meantime, thanks for tuning in here. Take care of each other. Be safe. If you're going to do something I wouldn't do, which leaves a lot for you. Anyway, take care.